Today I'm going to be talking about the most common, small but very significant blunder that a lot of defendants make when they are contesting any civil suit. For those of you who don't know anything at all about the law or legal practice, civil suits are suits. When someone says, I will sue you, this is what they mean. You file a civil suit against the other person to seek recovery of money, injunction, to restrain them from doing something, or to get a direction to them to get them to do something. So when you are a defendant, that is, a civil suit has been filed against you, this is the most common mistake that I have seen hundreds and hundreds of people repeat day after day after day. So recently, this person reached out to me for a consultation and was talking about his entire case and the fact that the written statement in his matter is ready but is yet to be filed because the court keeps adjourning the matter because of lockdowns, court strikes, etc., etc. And I interjected at that moment and I explained to him that he has also fallen prey to one of the most common mistakes that litigants and their lawyers do when they are defendants in a civil suit. Because the Civil Procedure Code, the law of the land passed by the parliament, which mandates how everything has to be done step by step. Everything that we do in a court of law, especially in civil proceedings, has to be followed to the letter. And of course, to the letter means also judicial interpretation of that particular statutory provision. One of the biggest mistakes, one of the most commonly made big mistakes that people do is that they do not file their written statement within the statutory prescribed time given to them, that is 30 days. So this person says, my written statement is ready. And I asked this person, what date was the plaint filed? The person said about 2 years ago on this particular date. What date were summons of this civil suit issued to you and you received a copy of that summons? The person said somewhere about a month after the civil suit was filed, I received a copy and I went to court. I gave certain documents. I gave certain statements at the preliminary stage pertaining to injunction orders, and after that the matter proceeded to filing of written statement. But it's been approximately 1.5 to 2 years since that written statement is ready but yet to be filed. And I explained to this client that the Civil Procedure Code mandates that within 30 days of receiving a copy of the summons, you must file your written statement before the court. It doesn't matter what date is fixed. And ever so often, I see this happening. Next date comes up and the defendant comes and hands the written statement to the court. The court takes it on the record. But if the plaintiff, who is the person who filed that civil suit, or his lawyer raises the objection that the written statement was not filed within time, and if it was not filed within time, there are certain extensions which are also granted, but only with the permission of the court and only after satisfying the court the reasons for the delay. So if you do not have an application seeking condonation of delay in filing that written statement, even in that situation, technically the court is duty bound to strike off your defense. And this is precisely what we have done on numerous occasions. We have, when appearing for the plaintiff, moved applications, I forget under which provision, but we have moved applications for striking off of the defense of the defendants. I have also on numerous occasions defended clients who have come to me at much later stages in their civil suits. And I've had a very, very tough time trying to convince the judge to take my written statement on the record and not strike off my defense. And I see this happening ever so often. So do not make this mistake. When you receive summons for a civil suit, you must file your written statement, which is the reply to be filed in the court, which is called a written statement. You must file your written statement within 30 days. I tell every litigant, do not take chances, do not seek to file your written statement beyond 30 days and then file these applications for condonation of delay. And on most occasions, because of the law that is there in the CPC, as well as the jurisprudence of the court, in all likelihood, your written statement will not be taken on the record. Or at the very least, there will be many months, years gone by, several lakhs of rupees spent on lawyers on just this particular issue. So save yourself the trouble. The moment you receive summons for a civil suit as a defendant, within 30 days, even on the 30th day, you have the liberty to file that written statement. And if you are not able to do it for whatever reason, at the very least, move an application for condonation of delay in filing the written statement. Explain in good detail. Don't make the mistake of adding one line or one paragraph, which is what a lot of people do as well. Courts say that you must give in detail all the reasons which prevented you from filing your written statement in time. Having said that, this is only applicable for the next couple of weeks, couple of months, I guess, because the Supreme Court of India did freeze the whole limitation aspect somewhere, I don't remember which date, but March of 2020, I believe the Supreme Court said, if I'm not wrong, 15th of March 2020, that the limitations in all statutes across the country have been rendered inoperative, frozen, I don't remember the technical term, but that is what the status is. So technically, if your litigation has started somewhere around February or January, February, March of 2020, and you were to you file your written statement, and for that matter, there are a host of other things, right? Filing your appeal, filing a revision petition, filing anything else where there is a time-bound requirement of the law to do a certain thing within a particular time. All of those have been frozen. But I am telling this to all my clients who come my way and for whom I am working. We cannot take the risk because the Supreme Court says until further orders. This was supposed to get shut down by March of 2021. But then when the lockdown happened again, the Supreme Court again brought back those orders freezing limitation until further notice. Any day now, the Supreme Court is going to say, unless perhaps the third wave of the pandemic and lockdowns happen again, the Supreme Court in all probability very soon is going to again direct the running of the period of limitation, all the limitations of not filing your written statement, your plaint sometimes, your appeal, your revision, whatever it is, within the time will cost you a lot of trouble. Be mindful of that. And in fact, if I am talking about period of limitation, it is very important for me to mention almost everything in civil proceedings. There is a period of limitation that you have to be mindful of. You've given some money, you cannot seek it after 10 years. You have, you've given someone a property, you tell them to vacate it. You cannot after 20 years tell them to vacate that premises. There are periods of limitation for you to do everything under the sun in civil law in this country and across the world, because the law says that you cannot be sitting on your behind the entire time, even when you know that there is something which you are required to do. And if you don't do it in time, even if you had the best case and you are completely right, the other person is completely wrong, they still get the benefit of your delay in approaching the court with whatever needs to be done. So be careful of that.